Reeves Immigration Law Group now brings you Immigration Law on Your Side.
All right, happy viewing to everyone. This is Immigration Law on Your Side right here at PHLV Radio. Mga kababayan, balik na naman kami ni Attorney Diza ngayon para makapagbigay ng serbisyo publiko sa inyo hinggil po sa immigration. So, after Valentine's Day episode ito mga kababayan. Ako, after Valentine's Day, we fast forward right away to the flip side nito. Divorce and separation. Ngayong buwan ng pag-ibig mga kababayan. You know, divorce and separation, they can be devastating and talagang napaka-emotionally exhausting, financially costly, and can even affect one's immigration status here in the United States. Naku, ang hirap saklap naman nun. A divorce before, during, and after green card may introduce new challenges to a permanent resident. Well, in other cases naman, okay lang naman. So alamin natin kay Attorney Diza, kasama na naman natin from San Francisco, California, from Reeves Immigration Law Group to help us understand mga kababayan kung ano ang epekto ng divorce or separation in one's immigration status. Attorney, magandang gabi po and welcome to Immigration Law on Your Side.
Happy Wednesday, happy good Wednesday evening sa inyo, Kuya Johan, at sa viewers and listeners ng ating programang Immigration Law on Your Side, PHLV Radio. So pagkatapos ng ating programa last time about marriage, at marami rin tayo nakuhang mga tawag at consultation about the effect of the pending divorce or separation. So this also, in continuation of what we discussed, kasi discuss natin kung, 'di ba, kung ano yung benefits of marrying a US citizen. So ngayon naman paano kung hindi mag-go through ang kanilang relationship at hindi pa nila na-file ang kanilang immigration benefits. So this is actually a very informative discussion ngayong gabi at tumutok lang sila para malaman kung paano ang gagawin. Pwede bang i-preno muna natin ang pag-file ng divorce or pag-file ng annulment or yung separation or anong gagawin? Diba? And sometimes, clients cannot just stand the relationship anymore, right? Especially in situations na may mga abusive relationship. Kuya Johan, I always advise our clients where mas alam mo kung anong nangyayari dyan if it's really a good time to, move out and, end the relationship. Kasi ayaw mo namang ma-jeopardize ang kanilang buhay at pamilya, at kanilang kabuhayan, etc., right, if they continue to live with an abusive relationship. So, tumutok lamang po kayo at i-discuss natin ang mga effect ng inyong immigration status before, during, and after separation.
That's right. Kaya mga kaibigan, ipadala na yung mga questions ngayon or here at Facebook, YouTube, and nandito din tayo sa Amazon Fire TV. And we're also live on the PHLV Radio app on our audio streaming. And mamaya po, podcast sa ating iHeartRadio, Spotify, and Apple and Google Podcasts. Attorney, simulan natin kaagad. Meron kaagad na nagpadala ng question. Alamin natin kung ano ang tinatanong ng ating viewer. Attorney, sabi niya, we have been married for over 3 months. But before we file for my green card application, my U.S. Citizen spouse told me that she does not want to be with me anymore. She doesn't want to be married with me anymore. Ayaw na, wala nang forever. All right? And will not do anything about my immigration anymore. Sabi niya dito, Attorney, is there still hope for me?
Well, yung full cooperation po ng inyong asawa, kinakailangan bago nyo matanggap ang inyong may file ang inyong green card. That's the general rule. So, once na wala pang na-file po sa inyo, hindi po ninyo makukuha ang inyong, unfortunately, hindi po ninyo ma-file ang inyong green card. Right? The only exception dito mga kababayan is when you can prove that your U.S. citizen spouse, right, is abusive. Yung pinag-usapan natin kanina, where, you can file an application and a green card under the Violence Against Women Act. So, it does also apply to men or, male applicants, hindi lang sa mga women, kundi sa mga male. But you have to prove, unang-una dito, Kuya Johan, na either U.S. citizen or lawful permanent resident ang inyong asawa, right? Number two, there is a cohabitation, actual cohabitation, kahit 3 months lang silang nagsama, Kuya Johan, as long as they can prove na, nagsama sila at may relationship. Di ba? And pangatlo, there is an abuse, and the abuse, as we discussed in our prior episodes, could take in many forms. Hindi lang physical, kundi pwede rin emotional, psychological, mental, and financial abuse. So, and also you have to prove good moral character on your part, and as a matter of discretion, pwede kayong i-approve ng inyong green card. So mga kababayan, right, pag wala pang na-file sa inyo at mabait naman ang inyong asawa at walang pattern of abuse, right, wala po tayong magagawa. Kundi, just probably wait for another relationship or for an immigration reform if you are in the United States. So that's the only way, mga kababayan, where you are able to file for an application with USCIS.
All right. How about attorney, kung na-file na ang kanyang petition, tulad nitong tinatanong ng another listener natin, my spouse has already filed the petition for me, but we separated before the approval of the green card. Anong mangyayari dito, attorney, sa application niya for the green card?
There are 2 possible scenarios dito, mga kababayan. Number 1, right, you just get the approval in the mail, which is actually happening now, right? Yung sinasabi nating waiver or interview waiver. So wala nang interview as long as you provided the joint documents, right, that you are married and cohabiting. Kagaya halimbawa ng you file your joint taxes together, right? You have a joint lease contract, you have joint bank accounts or credit cards together, life insurance, car insurance, medical insurance, lahat yan joint, no? And also, kung mayroon na kayong anak, yun ang pinaka-best evidence that the relationship is legitimate, right? So in that situation, even if you are separated, you might still be able to get your green card. Ang masaklap dito, mga kababayan, is if, let's say, the USCIS will call you for an interview, right? So patawag kayo ng interview, and then they require both parties, no, the petitioner, U.S. citizen spouse, and the beneficiary. In that situation, if the U.S. citizen spouse failed to appear, then USCIS has the right to deny the application, right? Yung petition at saka yung tawag nito, yung green card application ninyo based on abandonment. So yun ang posibleng scenario, pangalawang scenario. But there are also situations, especially if you hire a lawyer to go with you and discuss the issue, di ba, na wala na kayo dahil, di ba, you have to explain the reason why. Probably there's a restraining order against your spouse dahil sa kanilang, pang-abuso, or just simply because you just fell out of love at, nakahanap na siya ng iba, wala natin magagawa, o ikaw nakahanap ng iba, wala ka na magagawa. So those are the possible situations. It's still possible, mga kababayan, in your situation where you can still get the green card despite separation after you file your green card application.
All right. Maraming salamat sa mga tanong po ninyo. Just keep it coming kasi po dito sa Immigration Law on Your Side, kailangan nating maitanong kay attorney ang mga nasa isip nyo, especially with this topic. Attorney, a few episodes ago, napag-usapan natin itong conditional green card. May conditions ka, and if I remember it right, 2 years ang validity nito. How about within the 2 years, medyo nag-separate. Ano po ang mangyayari doon sa may conditional green card?
Yeah, the reason why USCIS requires conditional green card, yung issuance of conditional green card, is to make sure that parties are entering marriage in good faith, diba? So they're not using marriage to get a green card dahil malaki ang penalty ng marriage fraud, di po ba? So secondly, the other reason is because once you get your green card, and at the time of the green card approval, your marriage is less than 2 years, binibigyan po kayo ng 2 years conditional lang. Kasi, just to make sure na masyadong, maaga pa para ibigay natin sa kanila yung 10 years. So, for example, nagpakasal sila, Kuya Johan, ng 2022, ng February of 2022, right? And they filed the green card right away at na-approve within a year. So 2023 yung binigay na green card. So instead na makakuha siya ng aplikante ng 10 years, binibigyan ng 2 years. Kasi less than 2 years yung kanilang marriage at the time of the grant, di ba? So 2022, 2023, 1 year lang yung nakalipas bago na approve. So then bibigyan sila halimbawa January of 2023 hanggang 2025. And under USCIS regulations, the parties must submit what we call removal of condition or a joint petition to remove condition. As a general rule, you are required to submit this application with your US citizen spouse. Diba? So, natawag yan na joint petition. Right? So then, you also have to provide, may bayad ulit yan po Johan, and there's a form. And of course, you have to provide all the evidence of cohabitation for the last 2 years. So kung nakuha nyo ang green card nyo in January of 2023, lahat ng mga joint documentations ninyo from 2023 to 2025 when you file for the removal of condition. So halimbawa, nagkaanak po kayo, you also transfer to another place, so meron kayong bagong lease contract, meron open kayo ng bank accounts, or even if the old bank accounts that you presented during green card application, pwede pa rin yun, pero kailangan yung updated from the time the green card was approved conditionally up to the filing, right? And then you file your taxes together, you have visited the Philippines, and you have these airline tickets and photos showing that, you traveled together as a couple. So yun yung mga evidence, Kuya Johan, that you have to show that you are still married to and living with your US citizen spouse. But there are situations din na naghiwalay na kayo, right? At ayaw nang pumirma yung asawa. Diba? Sabi niya, wala na, I have nothing to do with you anymore. Forget about it. I'm not going to cooperate. Bahala ka sa buhay mo kung ma-deport ka, etc. Just because there are many situations, ang separation, as you mentioned kanina, could be devastating. Diba? Talagang, problema mo na yung pamilya mo, yung relationship mo, problema mo pa yung immigration status mo, and you also mentioned it's also financially costly dahil you're dealing with a divorce lawyer, you're dealing with what else, yung immigration lawyer, at saka yung mga expenses about childcare, etc. kung may mga anak kayo. So, these are really have a, devastating effects sa ating mga kababayan. So, but it's not the end of the world. I always tell my clients to seek a lawyer, advice kung anong gagawin kasi lalong-lalo na situation, litong-lito sila kung anong gagawin. So it's really a great idea to hire a lawyer, and work with you kung paano yung process to assure na you are in good hands and, in good, in order for you to get the green card pa rin. So, in that situation, Kuya Johan, may mga exception where you don't have to have your spouse cooperation anymore. So, bahala ka kung ayaw mong pumirma, I can do it by myself. So, unang-una dyan, you have to show good faith marriage. Right? Good faith marriage, meaning na, kahit hindi siya pumirma, merong checkbox yun, Kuya Johan. Anong basis mo for filing this petition to remove condition? Either joint petition, right, or waiver. Yung waiver na yan, may tatlong checklist yan. Unang-una, yung binanggit natin kanina, good faith marriage, waiver. Pangalawa, it could be an abusive relationship, yung battered spouse. Pangatlo, pwede ring hardship. Wag mo akong hindi pipirma asawa ko because there's hardship on my part. Pang-apat pala yon kung namatay na yung petitioner US citizen. So doon sa good faith marriage waiver, mga kababayan, yung unang exception ng joint petition, na you don't need your spouse to sign, but you have to provide all the list of documents that we mentioned showing that the marriage is legitimate. Now, it's also a requirement under USCIS that you have to have a divorce already at that point. So, doon malilito mga kababayan natin na hiwalay lang sila, you cannot file a good faith. Kahit may anak kayo, hindi pwedeng mag-go through ang good faith if you don't have the actual divorce decree. Meaning, yung final order of either divorce or annulment or separate or any way to terminate the relationship. So you have to have that finality of judgment of that divorce. Now, paano kung wala pa? Paano kung pa-expire na yung green card saka pa lang, naghihiwalay? So anong remedy po ninyo dyan? So pwede po nyo pa rin i-file, right, based on hardship, right? If a file mo, pwede rin based on tawag good faith, as we mentioned kanina na kahit wala pang divorce, but make sure that you file the divorce already. Kasi pag nag-request ng USCIS ng evidence showing na nasaan yung divorce decree mo, you need to be ready, to provide that judgment. Walang problema kung ang kababayan natin nakatira sa Nevada area, diba? Kasi madali mag-divorce dyan, right? But other situations where, like California or other states where they require you to, wait for 6 months, before a judgment can be finalized, right? Medyo mahirap yan. So what we advise our client is, if you are already separated, your spouse no longer want to cooperate, and you can show that there are bunch of documents showing relationship, mag-file ka na ng divorce. So by that time, USCIS will, will request for the judgment, ready na po kayo. So yun yung dalawang exception. Good faith marriage with a divorce, or you can also file a good faith marriage without a divorce, right? Pag pa-expire na yung green card ninyo, but you need to be ready to provide them the divorce once USCIS asks for it. Doon naman sa hardship waiver, mga kababayan, you have to prove then that pwede pa rin i-file yun kung wala pa kayong divorce. Kasi mga kababayan, right, tandaan po ninyo na kapag mag-expire ang inyong conditional green card and you failed to file the removal of condition, right, wala ka ng proof of green card, right? So either matatanggal ka sa trabaho dahil nag-expire na yung proof of work permit mo, hindi ka rin pwede mag-travel, di ba? And ang pinaka masaklap po dito, pwede kayong ilagay sa removal proceedings dahil na-terminate na ang green card ninyo. So make sure that you have to file something before your green card will expire, either on good faith, hardship, or battered spouse if there's also a proof of abuse. No, hindi lang po yung mga nag-green card o yung mga wala pa na ako ang green card, but you can also prove battered spouse, right? Your spouse no longer signed the joint petition, the removal of condition, but you have to show also the abuse, right? Proof of abuse kagaya ng police report, right, hospital records, bruises, picture of bruises, or TRO, yung temporary restraining order, etc. Or even your declaration alone would be sufficient, especially so if there is no police report or medical report. So ito yung tatlong exceptions na palagi nating na-encounter even if you no longer with your spouse at the time of filing of the removal of condition.
Mm-hmm. Talagang masalimuot and really very complicated ito. Well, divorce itself is complicated already, and then you figure in the immigration status. And as you know, mga kababayan, one of the most affected sa mga divorce na ito, especially kung may mga anak na. Attorney, paano ang effect nito just in case meron na silang mga dependents, in case meron na silang mga anak? Paano na apektuhan po ang immigration status ng mga bata kung nagkaroon ng ganitong hiwalayan?
That's really a good question, because we encounter this kind of scenarios all the time. So we can discuss this in a separate manner where, let's say, ang petitioner po natin is step-parent US citizen. Diba? So nagpakasal po kayo dito, nakapending yung green card nyo, tapos pinetition din yung mga biological children sa Pilipinas, di ba? Dahil, step-parent can petition their children if they're below 18 at the time of marriage. Now, kung let's say maghiwalay ng mag-asawa at willing mag-petition ay tuloy ng step-parent ninyo ang petition, okay pa yun, Kuya Johan. Kasi as long as they were married before 18 and they're able to establish a relationship, right, as the papers is in progress, right, okay pang ituloy yon kahit hiwalay na mag-asawa. That's maraming mga kababayan natin hindi alam yon, right? Pero syempre importante yan, kailangan ng cooperation pa rin ng petitioner kasi there are many situations, many times lalong-lalo sa ating mga Pilipino, right, where kung ayaw na sa asawa yung mga anak, bakit ko pa maging responsibilidad ng anak mong minor de edad, ba't ko pa sila dadalhin? Kasi the petitioner still has to sign the affidavit support, di ba, sa NVC at saka sa embassy. They have to provide that before the interview. So, maraming sitwasyon na na pumapayag. May mga sitwasyon na pumapayag pa rin ang petitioner despite, the separation. Lalong-lalo na kung nandito ang mga bata and they were able to establish the relationship. So, pwede pang ituloy yun. That's for the immigrant petition. Pero, let's say sa mga non-immigrant, di ba? Or non-immigrant category po natin, like kagaya halimbawa ng H-1B, right? Or yung mga investor visa or even student visa, may mga dependents po yan. Ang dependent po are legal spouse and minor children. So, halimbawa yung mga H-1B naman, nakapending ang inyong application, right? At finalan ko yung H-1B. At the time of the separation, right, or divorce, hindi na eligible ang dependent ninyo, right? Kung kayo hiwalay na at kung kayo separate na. Pero while the application is pending, kung legally married pa kayo at walang legal termination pa, pwede pang maging dependent. Ang problema mo diyan kapag magre-renew ka ng magre-renew yung H1B and magre-renew rin po kayo ng H4, hindi na po niyo pwedeng i-renew yun kung at the time of the renewal kayo ay divorced na. So, ganun yung sitwasyon. O limbawa, H1B holder po kayo, right? And then, final lang kayo ng ang inyong asawa ay H4 at mga minor children. Now, pinailan kayo ng employer ng labor certification yung principal, di ba? Yung asawa yung principal, right? At naghintay na kayo na i-file na yung green card application at naghintay na lang kayo ng priority date para maging available kasi may retrogression. Now, before the issuance ng green card, if you already are officially divorced, hindi na rin eligible ang inyong asawa as a dependent. Oh. So, patandaan po ninyo, if we can take a break and, ipreno muna ang pag-file ng divorce or separation just to, wait for the, for the green card, that's better, right? Hindi lang sa pamilya ninyo, lalong-lalong kung may mga anak kayo, but also for your immigration status. But again, ibabato natin ulit sa ating mga listeners and viewers na if you think your life is already miserable at you're in danger, right? You're in a better position to know what to do. Kailangan umalis na, hiwalay na. Huwag mo nang hintayin ang green card ninyo kung ang buhay ninyo naman ay delikado. So, yun po ang tandaan natin. So, yun yung effect, Kuya Johan, sa mga sitwasyon ng mga non-immigrant derivatives.
It goes without saying na yung kanilang employment authorization document, for example, the H4s who are now allowed to work, apektado rin yun. Mapapawalang visa rin yun, attorney,
Yes, apektado rin. It says dun sa denial, di ba, that any corresponding work authorization, even the advance parole, will also be terminated.
Okay. So let's talk about options, attorney. Just in case, say for example, na-finalize na yung divorce, hindi na nga nag-qualify for any immigration, na ituloy yung dating application. How can they, kumbaga, pivot and apply for another status na hindi na naka-anchor doon sa kanilang spouse? Is there a way na they can find a way to be petitioned by somebody else or petition themselves na hindi na nakadikit sa kanilang dating spouse?
Yeah, for people who are here on a valid status, for example, yung H4 natin na-discuss kanina, so bago kayo maghiwalay at nasa status po kayo at bago ma-finalize ang inyong divorce, or nasa student visa dependent po kayo, bago mag-expire, you can change status to another non-immigrant status. So sa mga H4, right, kung graduate po kayo ng bachelor's degree, right, or meron kayong registered nurses po kayo dito, then you can look for an employer to file a petition for you under EB3, right, or under H1B din, right, kung mga professionals po kayo. So before mag-expire, bago ba-finalize yung divorce, pwede ka rin magpa-petition. That's for sure. Those are possible scenarios na hindi ka na magde-dependent doon sa asawa po ninyo dahil maghiwalay na po kayo. Now, for people who are out of status na po kayo dito at nakahanap kayo na akala nyo forever at ready to file na kayo tapos nagbagong isip ng inyong asawa, right? Wala po tayong magagawa as we mentioned kanina unless there is a battered spouse at wala pang na-file sa inyo. So the other way to look for that is of course consult a lawyer para alamin natin kasi maraming options, Kuya Johan, di ba? Mm-hmm. may anak nga kayo, well, for example, marami tayong kababayan na legitimate yung relationship, may anak pa sila, kaya lang the children won't be able to help you until they're 21, di ba? So, paano kung 10 years old pa lang yung anak, yung asawa, na, kukuha lang yung green card o kasi citizen lang, ayaw nang mag-file sa inyo, anong option ninyo, di ba? So, it's going to be hard to wait for another 11 years para mag-21 yung anak, saka mo pala makuha ang green card. So, consult with a lawyer, immigration lawyer, to discuss the options. In that scenario, yung mga wala ng status. So, there might be other scenarios kagaya ng, ano tawag nito? Well, of course, immigration reform is always, an option that we look forward to it. Hanggang ngayon, wala pa yan. I've been practicing for almost ilang taon na, Kuya Johan, wala namang immigration reform pa. Wala pa yung kagaya ni Reagan na blanket immigration reform o yung kay kay President Bush yung 245I o Clinton and Bush yung 245I, wala pa rin yan. They were like small immigration amendments that really helps our kababayan, pero wala talaga yung blanket immigration reform. Now, as we mentioned kanina, hindi lang sa paghihintay na mag-21 yung anak yung US citizen, there might be other options like if you're a victim of crime, right? Hindi nyo po alam if there's possible asylum claim, right? Na you don't want to go back to your home country because something you have past persecution, because of your social group or political orientation, pwede rin i-explore yung option na yon. What else? Aside from the victim of crime, waiting for immigration reform, waiting for your children to turn 21, or an asylum process, there might still be other options. So it's really important to sit down with an immigration lawyer para i-discuss yung mga options po ninyo at hindi lang tayo nagre-rely sa inyong asawa na hindi naman pala karapat dapat na pakasalan dahil hindi kayo magkasundo or for whatever reason maghihiwalay po kayo.
All right. So, attorney, at this point, let's remind our audience, kung gusto nilang tumawag po sa inyo, how can they reach you po, attorney, whether they're here in the United States or back home in the Philippines or any other part of the world?
Yes, you can always check our website at Reeves Immigration Law Group. There are several offices where you can set for a Zoom or phone or in-person consultation here in San Francisco, in Walnut Creek, in Makati, in China, Los Angeles, right? We all, this is immigration practice is federal. So there, we practice all 50 states of the United States and also its territories, kagaya ng Guam and Puerto Rico, and also all the consulates and embassies worldwide. So may mga client po tayo doon. We charge $100 consultation for the consultation fee, right? That will be credited towards your contract if you decide to hire our services, right? You'll be speaking and consulting with immigration law specialists. All the partners here at Reeves are immigration law specialists, and even the senior attorneys, we require them to take the specialization exam. We cater and we specialize in immigration only. We don't practice any other law practice but US immigration. So yun po mga kababayan, at as you see from sa ating di ba, sa ating screen, nandun po ang aming law firm at ang ating contact number.
All right. 415-568-3777 mga kababayan para makontak si attorney. Attorney, bago tayo humingi ng mga updates sa inyo, napapag-usapan natin yung H1B kanina. It's H1B season. I'm sure it's crazy out there. Yung mga application, naghahabol to register. Attorney, baka meron pa kayong ibang mga takeaways sa ating mga viewers regarding the effect of divorce or separation in one's immigration status.
Yeah, this change of your life, especially filing for divorce, undergoing divorce, should not affect your immigration status if you do the right way, right? By consulting a lawyer, walk with you the process. It might be very, very difficult, especially at this time, as I mentioned to you, na you're undergoing divorce, etc., financial problems. But your immigration should be, as long as you gather documents that the relationship is genuine and legitimate, you should be okay. The only thing is how to file those applications, what kind of application, and what to take in dun sa mga legal forms. So it's really a great idea to to talk to a lawyer para alam po ninyo ang tamang paraan. Yun lang po ang pinaka best advice natin to those people undergoing separation or divorce. So, contact us as you see sa inyong screen ang ating opisina at Reeves Immigration Law Group.
All right. And attorney, at this point, I'm sure the immigration world is very, very busy para po naman sa makapaghanda sa susunod na fiscal year, which starts in October. And as you and our other partners at Reeves Immigration Law Group, Attorney Eric Wells, we talked about H-1B a few episodes ago. Attorney, kumusta na po ang filings ng mga H-1B at this point na I'm sure malapit ng mapupuno na naman ito, attorney?
Yes, we are actually very busy preparing for the application from the employers, so registration to make sure that we are one of the lucky, parang lottery, and it's actually a lottery. You're competing with the big companies with several hundreds and thousands of employees, right? But this is a busy season for employment-based cases, and sa mga kababayan natin na hindi pa nagko-consult ng abogado, it's time for you to consult us so that we can help you register, right, with Department of Labor for your H-1B. If and when for the next episode, kasi ang start ng mga fiscal year, as you mentioned, would end in October, but the filing is in April, di ba? April 1. But the initial registration would be in March. So that's going to be next month already. So it's really important, mga kababayan, that go ahead and consult with a lawyer, identify your employer, right? Yung mga employer naman, you have to discuss with your lawyer how to process this so that we can help you with the registration. So yung H-1B is really a busy season for employment-based lawyers like us. Dun sa filing fee increase, Kuya Johan, effective April 1, as we mentioned last time, right, marami sa mga kababayan natin na hindi pa nagpa-file yung kanilang citizenship, yung kanilang petition, right, there is a vast increase ng filing fees effective April 1. So, plus, I would like to remind you that election is November, right, and at this point in time, hindi lang H-1B ang busy, kundi mga nagna-naturalize din. We always advise our client na and the people out there who are already eligible, file now, because this is the time where USCIS will expedite, not necessarily expedite, pero yung talagang process nila, mabilis sila ngayon, and some, what do you call this, busy USCIS offices will do same-day oath ceremony.
Wow.
Right? Yung iba naman, nakukuha na yung oath notice right away after the interview. So, may mga client tayo na 2 months, 3 months from the time of filing, they already received the interview appointment, Kuya Johan. Like, unlike pre-COVID, usually ang processing time is 6 months to a year. And during COVID, umabot ng 1 to 2 years. So ngayon, 2 to 3 months, you're able to get your interview, and hopefully everything goes well. You have same-day oath, or, you get the approval right away and just give you the notice at that point. So it's also the naturalization, what do you call, season, dahil it's going to be fast because they want you to become a U.S. citizen, and hopefully you participate in the election process this November.
Oo nga pala, para makapag-boto. So for those who are eligible, why not? Di ba po, attorney? Ayan. So, may fee increase pala, mga kababayan. So, don't wait. Tawagan na lang po ang ating mga kaibigan from Reeves Immigration Law Group. And if you have more questions, you can send it over here at Immigration Law on Your Side, right here at PHLV Radio. Nako, malaman na naman ang ating discussion ngayon, attorney, especially towards the tail end of the love month. Hiwalayan ang pinag-usapan natin ngayon. Pero this is just the reality of life, mga kababayan. Kaya magandang ready tayo sa mga options katulad po ng mga na-mention ni Attorney Diza. At syempre, kung kailangan yung tumawag, ayan na, naka-save na yung number ni Attorney Diza at para makapag-konsulta na po kayo. So, attorney, I'll give you this time to address our audience. Baka meron po kayo mga ibang announcements.
Yes, maraming salamat ulit, Kuya Johan, at PHLV Radio for this opportunity to give public service sa ating mga kababayan regarding their immigration issues in the United States. Our topics were actually taken from the most consultations that we have during the month. So, as much as possible, ayaw nating iulit-ulitin. Pero even then, nagko-cross yung mga topics, which is also very helpful sa ating mga kababayan.
That's right.
Para malaman kung ano yung process, no? Pangalawa, Kuya Johan, at yung free legal services ng Philippine Consulate dito sa San Francisco every first Friday of the month. So, ang susunod po, nandun po tayo, March 1, right? That's going to be in person. People who goes to the consulate at the embassy at the San Francisco office, you will be meeting with IBP officers and members ng Integrated Bar of the Philippines California chapters. Marami pong mga abogado doon. This is regarding hindi lang po immigration, kundi Philippine matters, Philippine laws, kagaya ng property, paano po magpaparehistro, paano yung inheritance ko sa Pilipinas, right? Paano yung mga annulment ko sa Pilipinas. So anything that has to do with Philippine laws, those immigration, rather IVP lawyers will help you. And also, Kuya Johan, sa March 13, there's also a free legal service dyan sa Las Vegas, which hopefully I will be attending, right? Hopefully I can meet some of our Las Vegas residents dyan on March 13. I'll be there in person. Hopefully, hindi po magkakaroon ng future conflict, diba, or mga other cases that needs to be attended. Yun lang, Kuya Johan, at maraming salamat ulit, at sa mga viewers and listeners natin, please like and share ang Facebook page ng PHLV Radio, Reeves Immigration Law Group, at yung aking personal Facebook page, FJ Diza, Reeves Immigration Law Attorney. Maraming salamat ulit at mabuhay tayong lahat.
Mabuhay po kayo, Attorney Diza, and everyone at Reeves Immigration Law Group. Maraming salamat po. And for those who are just coming into the program, napag-usapan po natin ang epekto ng divorce and separation sa inyong immigration status. Hindi lang sa inyo, pati po sa inyong mga dependents, para malaman nyo kung anong mga options po ninyo. Mangyari lamang po na balikan ang episode nito sa any platform of your choice. Maybe here on Facebook, on YouTube, on Amazon Fire TV, or dalhin sa inyong mga telepono as a podcast. Pwede na po nyong i-download ang audio version, and habang nagtatrabaho po kayo, marami tayong mga nurses na habang nagtatrabaho sila, attorney, ay nakikinig sa kanilang mga earphones as a podcast ang Immigration Law on Your Side. So maraming salamat po, attorney. Maraming salamat po sa inyo lahat. This is Immigration Law on Your Side, brought to you by Reeves Immigration Law Group. We will see you again next time. Maraming salamat po.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees, even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.
Reeves Immigration Law Group has just brought you Immigration Law on Your Side, Wednesdays 7 p.m. Pacific on PHLV Radio.